I'm Angela Diffley. I'm the co-founder of the Restaurant Technology Network, and you are attending our town hall on chatbots today. And we are really excited to have a legal expert who's going to give us some solid advice and guidance regarding what's going on in the way of chatbots, all of these different types of ways we're communicating now in the restaurant industry with our customers and even with our staff sometimes open ourselves to a lot of liability. So we've got Odia on the call, and she's going to share so much guidance that I rarely hear talked about in our industry amongst our technology circles. So I'm thrilled to have her share some of her best practice advice. And she's in the trenches looking at this stuff every day. So she's got a great way of explaining it in sort of a common sense kind of way that we can all grasp and understand. So it's great to welcome her here. Again, her name is Odia Kagan. Here is her information. As you can see, she is a partner and chair of data privacy and compliance in international privacy at the firm Fox Rothschild. Hello, Odia, and welcome to the program.
Hello, nice to be here. Sorry for the delay. Zoom was not cooperating with me, or I was not cooperating with Zoom, one of the two options. So we can dig in. What I want to do is a couple of things. One, I don't have slides because I don't like slides, but I will post a summary of the key things that I mentioned during the talk on LinkedIn. So I welcome you to check it there and follow me so you can get more updates if you're interested. That's number one. Number two is I am happy to take questions. And what I will rely on is Angela, though, and her team to field the questions in order for me to be able to pay attention to what I'm talking about, which, is always helpful. So I want to start with the discussion. We're going to talk about chatbots, and chatbots are all the rage now. And we'll talk about the legal issues associated with them, specifically in the privacy realm, but sort of not only. I think the first thing that I'd like to say is you guys can see for yourself, I think, at the top of my screen, there is it says recording, and there is a red button next to it. That's a red little dot next to it, right? The first and I don't know if you guys, when everybody dialed in, there was a pop-up. I actually didn't notice, but usually there is a pop-up, and those pop-ups are customizable by companies now. For Zoom, for Teams, you can customize them. Those are important because recording, when you record a chat, the first thing that happens from a legal perspective is that this is subject to the wiretapping laws. Those of you that are joining, those of you from the U.S. and the rest of the world, there are also similar laws. But in the U.S., there are states, I think there are 12 of them, that are two-party consent states where you cannot record audio without the other party's consent. And so the first thing, in this space, we'll talk about chatbots. Those of you that are looking at the news see that there's not a day that passes by without some sort of pixel. The issue in this, one thing that we're seeing is basically everything new, everything old is new again. So wiretapping, right? The old days of the switchboard, and the person in the switchboard was listening in on calls and things like that, right? Now that's happening, but it's happening via trackers or the third party that you are using to actually make your chatbot work when you are not doing it in-house. So the first thing to remember is if you are recording the chat is being recorded automatically, etc., wiretapping laws can be implicated. You should get consent. This is not consent in the new way of thinking, meaning you can basically force it. Whether or not you want to force it is a different question. Legally, you can, meaning if a person doesn't want to be recorded, you don't have to let them have the option of joining the call, right? The most common way of getting this consent that everybody's familiar with is on, when you call a call center, right? This call is being monitored, right? For quality control purposes. We've all heard those. Chatbots, it's the same concept. You need to open the conversation with either a pop-up and an okay, or the first message of the bot needs to make it clear that the conversation is being recorded. So you have to tell people, and it's got to not be something that's missed, right? So that you can get this consent, the implied consent by behavior, right? By keep being on the line, right? From a consumer protection, consumer relationship point of view, you may actually want to give people the option to do it, because people that are wary of being recorded, and there are people, there are many. I just posted something about recording of conversations or chats the other day, and I had a bunch of reactions saying, well, if I know I'm being recorded, I'm going to hang up and I'm not going to do it. And there are a lot of people that do that. So for depending on the functionality of the chat. So I've seen chat bots that are, serve is part of, like, in lieu of or to assist a customer service representative. So in those situations, you don't want to turn people away from your service. That is kind of what you're trying to do. You're trying to make it easier for them and attract them. So if you do have an alternative way, right? A website, an actual call center, an email, something like that, then say, this chat is being recorded. You need to say what is being recorded for. And if you don't want to be recorded, you can go here or here, right? That's one thing. The second thing is the specificity, right? And I will talk about this throughout, but one important concept here in accept the consent, right? The disclosure and sort of consent of the recording. Other state laws and FTC and apply to this. Why? Because may apply to this. Let's say that. In the course of your conversation with the chatbot, there may be personal information that is collected. Either you're collecting the name of the person, you are logging, right? Like when you talk to, sometimes I've done this with like airlines or whatever, like they ask for your name, or they're logging your device ID or IP address or something. If you are collecting personal information and logging it through the customer's account or something, now you've collected personal information. And now you are subject to all of the relevant state privacy laws, of which there are 19, and a few of them are already in effect, and FTC, unfair and deceptive acts or practices, etc. And so you need to do all the things that you need to do when when personal information is involved. And so, as you know, one of those things is disclosure, right? Like the privacy notice. Those are those requirements. So you need to have it in your privacy notice. You need to address the chatbot in your privacy notice, but also it is either a good idea or required, depending on where you are, to have something called a notice at collection, which is like a just-in-time notice immediately at the joining. Now, this is a very opportune time to do it because you already had to say this chat is being recorded. And you need to say why the chat is being recorded. So you might as well add those other things that California requires you to, say, right? Like, what are you collecting? Why are you collecting it? What are you doing with this, right? California also requires you to disclose a couple of other things. And so that's a good idea to kind of put the full disclosure on this. So address the recording, tell people what is going on. And then tell people what is going on, both in your privacy notice and in your notice at collection. Now, the prerequisite to tell people what is going on is that you have to know what is going on. That seems stupid, but it is important. Why? Because in some situations, it's very straightforward what you're collecting, right? You are recording the call. You are also recording who the call is from, right? Who the chat is from, right? The user's information. You also need to account for two more things. You need to account for passive collection of information. Are there trackers embedded in your chatbot? That is an important question to ask either your development team or your vendor, because in a lot of cases, you get a third-party vendor that gives you a chatbot.
Mm-hmm.
You need to ask them about tracking. You need to understand what the tracking is, right? These are cookies, they could be SDKs, they could be embedded code. There are a lot of ways to do tracking. And the second thing that you need to ask them, so what is the tracking and what does it do and why, right? And then you need to investigate. So for example, if you have Google Analytics tracker in your chatbot, that is a sharing of your information with Google. You need to figure out what that allows Google to do with the information, or Metapixel, or whomever, or what is your chatbot provider allowed to do with the data that they get exposed to when they provide your chat. That fact pattern, either specifically with respect to chatbots or with respect to other types of sharing through third-party trackers, have been the subject of a ton of class action lawsuits. There have been class action lawsuits specifically with respect to chatbots about wiretapping, right? You didn't tell us that you're sharing the information with a provider. So that's what I said, right? You need to tell people what's going on. We are providing chatbot with a provider. If the provider is allowed to use the information for their own purposes, which like Google Analytics sometimes is, etc., that is something that, one, people need to know, and the FTC thinks people need to know, and state UDAP, state consumer protection, unfair or deceptive acts or practices laws want people to know. And California, for example, and the other state laws consider them a sale or a share, and you need to provide an opt-out from the sharing. And that one, right, you have to give. So remember in the beginning, I said, you want to give an opt-out out of the recording, cool. You don't want to give an opt-out, you don't have to. But for if you are sharing information with a third party, and the third party can do what they want with this information, you are required to give people an opt-out. And so you need to have that part under control. Another type of, and those may not be obvious from the surface. You need to ask your provider. I have had situations where I looked at the privacy notice, I looked at the agreement with the provider, the data processing agreement, and I still didn't understand. And we had to have a conversation with the provider, right? What information are you collecting? What are you doing with this information? What are you allowed to do with this information? Those are already in play, and they are already active case law. FTC enforcements in third-party trackers, BetterHelp, GoodRx, XMarket, InMode about sharing through trackers and sharing through SDKs. Those are already in play. Another point to kind of think about more conceptually on the recording, which has not yet hit the US soil. It's like let's call it like privacy enforcement hurricanes, right? It hasn't made landfall yet, but we've seen it gaining speed, right, in Europe, is this concept of data minimization, which means ask yourself, do you really need to record this chat? How much of the chat do you need to record? Do you need to record all of it? Do you need to record just the answer? Do you need the answer tied to a profile? Like, think about it. Like, I have a conversation with a client where they are recording something, but they're only recording the answers. They are not recording the questions, and they are not recording who the person is. And in that situation, you can turn something that would otherwise be personal information and subject to laws to something that is not personal information, and that disclosure could be proprietary information. So let's say, for an example that I've worked with clients on, they're using recording chats to improve their product, right? They're getting feedback on their product, getting feedback on customer service, getting feedback just generally, not even like personally on, this guy, this, this server was really bad, but just generally, like, we like our, this type of burger and this type of bun and this type of drink, right? Those, for example, would not be personal information if you are able to not collect personal information or not give, for example, your provider personal information. Those would be proprietary information, because now, if everybody's talking about like the consistency of your shake or the crispiness of your fries, right? Like that's something you don't want to share maybe without compensation, but that's between you and the provider on a commercial level and not in privacy. So think about one, can you get out of privacy laws by limiting the recording? And number two, again, and we'll talk about sort of the more complicated use cases that I'll touch, right? The more sensitive the stuff, the more this is going to come up, because the FTC has talked about data minimization. And so the more sensitive the things that are happening, the more important it is that you are able to either not collect them at the outset or not retain them, for example, right? For example, you could transcribe, cut out things of the transcript, and dump the recording. Do you need the voice recording, or do you need the transcript to retain it, or do you need to retain it in an identified way, right? So those are questions that it's a good idea to start discussing because of 3 reasons. Reason number 1, if you have information that is sensitive or breach reportable, and this would not be in sort of your kind of consumer facing stuff, but let's say you're using a chatbot for HR functions and things like that. You're talking about medical leave or talking about grievances or something like that. Those could be breach reportable. If you're retaining something that's breach reportable, it gets breached. You didn't really need to retain it because you grabbed the right information. Now you have this information stored in some log of the chatbot. That's breach reportable. You got to report it. You are also subject to right of access requests, which, as you know, are basically, free, legally sponsored discovery. So you could get requests for transcripts of the chatbot. If you don't retain them, you will not get requests for the chatbot, unless, by the way, there are requirements under, if you're using this for HR purposes. I don't know if you are, there are going to be like state specific or labor law specific requirements for retention. So you might need to retain it, but if you don't need to retain it, or if you're retaining it once somewhere else, then, consider not retaining them in the bot. So those are kind of general concepts on, you need to tell people about the recording and why. You need to tell people that you have a service provider. You need to tell them in your privacy notice and immediately, and you need to know exactly what is happening. What is the information you're collecting? Are there trackers? What's the service provider doing? And could you be doing less, right? From a data minimization perspective. Sensitive, specific things to keep in mind that are more risky. Anytime you are dealing with children's information, so under 13s, definitely. This is already litigated. There is case law. It's in the millions. It's not good. But in this industry specifically, because I see, my kids interacting with apps and things like that, you now need to start thinking about teens too. So it's not under 13. It's also like the 16-year-old, and maybe they have a debit card, and maybe they have, or my kids don't need to have a debit card anyway, because they have Apple Pay or Apple Cash or something, and they can just pay themselves. There are new laws that, first of all, COPA itself, if you have something that is targeted at teens, there are things you need to do under COPA, the Children's Online Privacy Protection Act, too. But even separately, you now have laws, Connecticut, Maryland, that are applicable to things that are likely to be accessed by a minor, which is like everything pretty much. And there are requirements there. And the requirements span between, disclosures and rights to things that you absolutely just cannot do with the teen's data. So for example, collecting precise geolocation of the teen, you are not allowed to do unless you really, really need to. And then, we just had this with a vendor where we found out of the blue that the vendor is collecting precise geolocation for you needed to figure out, why is this happening? Is it really necessary? And if it's not necessary, don't do it. Precise geolocation is sensitive, or you can't use it for behavioral advertising, right? targeted advertising for teens. So the teen issue is warming up in the US and is something definitely to keep in mind. And other things are probably less relevant in the consumer facing, customer facing things that, restaurants do, but could be in the HR context, is profiling, or actually like in consumer, customer service, like emotion recognition, or, kind of and language analytics to figure out, is this like, is this person gonna sue us? Is this person gonna quit? Things like that. Those are more those are risky. When you analyze behavior in order to make decisions, and the decisions, for example, could result in somebody being, a disciplinary proceeding or termination of employment, those have a lot of things around them that need to be done, including a risk assessment. So those are kind of things to keep in mind. Now, the FTC has been active has been outspoken about chatbots specifically, right? The FTC has entered the chat, and it said the following things that are important to keep in mind. Don't misrepresent what this chatbot can do. So there have been lawsuits, also FTC enforcements, but actually class action lawsuits on like, what does this chatbot do, right? So the FTC has said your therapy bots aren't licensed psychologists, your AI girlfriends are neither girls nor friends, right? And your AI co-pilots are not gods, right? Like, this is from the FTC, paper, right? So you can't also represent, there's a company that got sued for this, you can't represent, for example, accuracy. Our chatbot is so accurate, is 99.7% accurate. That is a risky statement anyway, but if you're making it, you gotta be certain that you can stand behind it. So don't make promises on our chatbot will guarantee that you get, a job, or you get promoted, or you get whatever, or something. Don't make overpromise things that your AI or your chatbot can do. Don't offer services. Don't replace, for example, and there are a couple of companies that have been vocal about this. Like, we've outsourced all of our customer service representatives to chatbots. Don't offer services via a bot without adequately mitigating risks of harmful output. That is sort of an FTC fancy statement for risk assessment. And the risk assessment here is not to you, which is the normal risk assessment. It is a risk to the people. Like, what could the person being on the other end of this chatbot, what harm could they come to from what you are doing in the chat? And that, for example, and the CFPB, by the way, in the financial context, has also said that, right? If you're using a chatbot for customer service and the chatbot is bad, that means your customer service is bad and you're going to be liable for it being bad, right? And if it is and either that's just, PR, reputational issues, or it could be legal consequences. You need to conduct a risk assessment. If your chatbot is doing anything more important, right? Like things that could impact employment, things that could impact, eligibility to employment and things like that, that's more risky. And you need to make sure, right, that it is not discriminating against people, for example. Don't, first of all, and the obvious, which I said in the beginning, but I repeat again, not only do you need to say this is recorded, you actually need to say you are speaking with a robot. This is AI. Hello, this is AI. It's not, I'm not, but this is AI, right? Why? For two reasons. One, if you don't say that, it's misleading, and people might think that it is not, and that you're not. But that is not okay. The second reason is there's research that shows that people have some sort of positive bias for computers, right? like they think computers are more like AI or whatever is more reliable than people. I think, the more people interact with ChatGPT, maybe the less they will think that. But right now, there is some sort of confirmation bias pro AI. And so if somebody, so you want to make sure that people know what is actually, that they're actually talking to bots. It would actually be a good idea to say, you're talking to a robot and robots can make mistakes because they can. And they do very often. I actually read some sort of I was using as legal service this week that actually made up an amendment of the CCPA. And I read it, and it's referring to, and of course, and that's the advice, by the way, that I'll say in the to-dos, but always check, right? And always tell the users to check. Like, let's say you have an AI bot that helps people apply for a job or, I don't know, interview for something or whatever. Always, like, either if the person can independently check something, tell them you can independently check. Or let's say you have a bot that queries your database for things and you want to make things easier for your workforce. You have like these FAQs and it's querying against the FAQs. That's cool, but make sure that you tell people to, when you're using this output for any decision making, insert your own decision making and your own thinking process into this and go double check, which I did. I went and I checked this bill and I went and I checked it in 3 different places and it doesn't exist, right? This amendment never happened. And that is important because these things happen all the time and these hallucinations happen all the time. The FTC also, if you have bots and you're thinking, wow, this is a cool idea, we're going to insert ads into the bot. Don't do that without clarifying that it's paid content and that it is an ad, right? Also, the other thing, which is also from a consumer protection perspective, you probably heard about the FTC's Click to Cancel initiative that is going to make canceling subscriptions and memberships easier. The FTC also said, don't use the relationship that people develop with the avatar to make it, don't manipulate it to make it harder to cancel. So for example, the FTC says your friendly bot or avatar that's talking to you shouldn't plead not to be turned off, right? Like you should not, what you're not allowed to do in normal and making the cancellation hard, don't use like the cute bot to say, oh, please don't turn me off. I want to keep helping you. Don't do that. And then the other thing that we already talked about, which is transparency and disclosure. Last topic that I want to talk about before I discuss a few to-dos and kind of open it for discussion is the involvement of AI or generative AI in the bot context. So the first thing I already said, which is the person interacting with the bot needs to know it is a bot. And when you have generative AI or generative AI or AI generated content, you need to distinguish between content that was generated by the AI and content that was not. If you have an AI generated summary, you need to say this is an AI generated summary. And so that is especially the FTC was especially concerned with respect to children, but also other vulnerable populations that can't distinguish between AI generated ads or like organic content or whatever. So people need to know that this is AI. The other part, especially when you're using AI for any type of recommendations or any type of decisions, right? First of all, it's really important if you are using AI for anything, let's call it, as some laws do, consequential decisions, right? That's the Colorado term. Other laws use even more legalese term, which is legally or similarly significant effects. That is even less clear, but consequential decisions, right? Access to financing, access or opportunity for employment, for education, health, mental health, sexual orientation, anything that is sensitive and anything that could affect your, could affect union membership too. Those, if AI is used to make determinations that could impact one of those things, all your alarm bells should be on, and you should speak to, a good attorney near you, because those require things. They require a risk assessment. They require figuring out if you're even allowed to do it. But when you're using AI, even for other things, you need to know what data it was trained on. Is this data okay? Could it be biased? Rite Aid, for example, this is not a chat situation, but Rite Aid, for example, used AI-based facial recognition for shoplifting, and the FTC entered into an enforcement action against it because it said the actual technology, the facial recognition, wasn't properly vetted, and it was discriminatory. It did not distinguish well against people of color, and it had a lot of false negatives, false positives, false negatives, and there was no way to fix it, right? So you need to figure out if it's discriminatory for some reason, if you have, if you're depending on, the different applications, was it trained on infringing material, right? Like copyrighted material, trademark material. There are lawsuits out there and enforcement actions on this topic against OpenAI and others that are still pending. So it is not 100% clear if there is an issue with your data that you used, how you will be liable. But what is clear is that if because of that issue, you are discriminating or you are infringing, then you're liable, right? The FTC basically said, and that's sort of the overall statement that they made, is if you are not allowed to do it yourself, you are not allowed to use AI to do it, right? So if you can't discriminate, you can't have your friendly chatbot discriminate, right? If you can't infringe copyright or trademark, you can't have your chatbot infringe copyright or trademark, right? Another thing to make sure or to know, and then to give people choices, and that's been all over the news and you've probably seen it, is the bot, and that could be the bot or you didn't know that the bot was doing it, or you didn't know that your vendor that provided the bot was doing it. Is it using the data collected via the chat to train the AI model? And if it is, what do you do about it? There is a discussion on what can be done about it, but at minimum, on whether or not this needs to be opt-in or not, but at minimum, it needs to be a notice and it needs to be the ability to opt out, right? I just saw this on, LinkedIn discussed this. There's the discussions on different companies that sort of turned on that ability. Zoom had a discussion, Zoom itself had a discussion about this when they changed their terms. So are they doing it? At minimum, right? You need to know what is going on. It is not a good idea for you to have your stuff be training AI and you don't know about it. That's like the worst option. First of all, know about it, then assess the risk and figure out what you need to do about it. And we talked about bias, we talked about mistakes and hallucinations, and we talked about like emotion recognition, because those are all important issues for the AI. And so finally, I'll talk for a few more minutes and then, I can get questions, but let me sort of summarize on, okay, so what do we do from here? If you want to launch a chatbot, you need to, first of all, do your homework and know what this involves. If you are using a vendor, vet the vendor, vet the product. Does the product do what it needs, what it's saying it does, right? It knows how to do. Can it really, query your database and reach the right answers? Can it really navigate somebody through a process? Can it really provide answers, right? It needs to be reliable because you are, one, making, a representation that this is a service you're giving, and two, this is your customer service, right? They're the face of the service. And if they do a bad job, like the CFPB said, right? If your customer service AI is bad, then your customer service is bad, period, right? So first of all, understand, is it fit for purpose? Is the data it was trained on, is the data you're using, is it legal? Could it be discriminatory? Is there bias that could be involved? And then if there is anything sensitive involved, children, teens, health, mental health, sexual orientation, political views, union membership, employment eligibility, education eligibility, and financial services, essential services, anything like that, get legal advice, do a risk assessment, figure out what you need to do. What do you need in order to deploy it? Once you know the stuff, you need to tell people about it, right? You need to have some sort of immediate, just-in-time notice that tells people, this is AI, this is being recorded, and here's what's happening. This is the data I'm collecting, this is how I'm using it, this is who I'm using for it, etc. You need to have it in your privacy notice as well. And you need to, we said about vetting the vendor before, but you also need to have the right agreements with anybody that touches this type of information. You need to have a data processing agreement with the vendor, and you need to consider or assess like risk, like what is the risk that you're taking. If you bought a system, you're on the line for it, of course, but the vendor that you bought it from could also take a share in the liability if something happens that you weren't aware of. But you need to make sure, obviously, that the agreement says that. And so those, I think, are the key to-dos. And the last thing that I would say, because we said in the blurbs, right, the different causes of action, there are a lot of different lawsuits about this. They are wiretapping, they are invasion of privacy, they are unfair or deceptive conduct, they are even, there is a lawsuit now with respect to tracking where the class action was let to proceed even under a CCPA cause of action, even though CCPA does not really have a litigation prong, with the idea, which is innovative for the US, but we've seen in Europe, that if you as a party allow the leakage of information, this accidental sharing, that is unauthorized access that you allowed, and you didn't have sufficient protections in order to prevent it, which is an obligation that you have under the CCPA. And so that's really interesting. But the main point that I would like to make is, but mostly because both because I'm not a litigator, because I do compliance, but also I think it's like sort of post-litigation or meta-litigation, right? I think that you really need to be mindful of the fact pattern, right? If your fact pattern it's fine that, let's say, under like there have been a bunch of lawsuits that have been dismissed on like CFAA, the Computer Fraud and Abuse Act, or California Medical Information Act, or things like that. But the same claim was allowed to be amended, brought again in a different cause of action. So if you look at the facts, and the facts are there's personal information involved, or it's sensitive, and it was shared, and I didn't know, or it was an accident, or people didn't know, or people couldn't know, and something could happen. Like that, look at the fact pattern and realize that even if this particular, it's like a whack-a-mole, right? If this particular cause of action was just thrown out, there might be like 16 others under different laws. And so it is better to kind of understand the concept, which is people need to know what is going on. They need to know the impact. You need to be responsible to mitigate the risk that you may be causing them, and address it at the outset. I'm not going to say as opposed to defending in litigation, Litigation is usually not an if, it's a when in certain cases, kind of like, breaches, right? But you want to, because they're unexpected, and the fact that something gets filed doesn't mean it's accurate. It could be dismissed. So you can't prevent not getting sued, but you can put yourself in the best position to deter frivolous lawsuits and to be able to defend against and get dismissed quickly things that are filed because the facts and the preparation was on your side.
Odia, that's awesome. That's a lot of information. I just want to say that I'm like absorbing everything. I heard so many new terms that I've never even heard of before, which I'm going to remember. That were super interesting to think about. We do have a question in the chat. Tim Tang, you had a question. If you want to speak up and ask your question directly to Odia, that'd be great.
Yeah, thank you. Thank you very much for all this. This is a lot to take in. I guess maybe starting with the third part, I'm interested in understanding how much of the a retailer or a restaurant is responsible for their third parties, third party mistakes. I mean, you kind of mentioned earlier, hey, it's your responsibility to understand what your third parties are doing with data. It's your responsibility to understand that they're properly, using clean data, so on and so forth. But that's a point in time. I mean, what's the expectation, a month from now, or 6 months from now, or they continue, these solutions continue to adapt and the like? Is there just an ongoing obligation to know everything about what your about the technology and how it's evolving and the data sets that are being used?
So that's a really interesting question. And the real answer is we haven't seen instructive, a conclusive answer on the actual allocation of the liability. But what I can say is this. At the end of the day, or the beginning of the day, however you want to say it, you're the consumer-facing entity. It's your customers, it's your reputation, and it's your data or your users' data. So definitely, you're going to be the first, line of defense, and it's your liability. Then the question is, how much and to what extent are you going to be able to go back to your vendor to say, hey, what gives? And the answer is one, it to some extent, it doesn't really matter because it's, again, like your reputation on the line, right? If your chatbot messed up, right? It's at the end of the day, it's your data, it's your issue that you will need to deal, and the reputational damage alone will be problematic. So basically, and in Europe, we have this concept called like a joint controllership, which may apply in certain situations here. And it's the same thing, right? Are you 90-10? Are you 60-40? Like, what's the allocation? That part and the sort of concept of product liability in connection with AI has not been conclusively decided. But what can you do? And you don't have, it's like, I'm a fan of Stoic philosophy. And one of the key principles they say is that you need to, be concerned with things you have control over, and not worry about things that you don't have control over. And so here you want to focus on what do you have control over? You want to put yourself in the best position possible. What is that? You vet the vendor to begin with. So we have, the FTC too, and we, I've had conversations where, oh, why'd you select this vendor? What other vendors did you look at? Oh, nobody. Why? So first of all, like, vet the vendor, pick a good one, be mindful about why, answer the question, which also I've had in certain situations, the basic question. Do you really need a bot or AI for this? Can you, like, do you need to do this? Is it done better? I heard as a joke once that as generative AI was rising, somebody said, wow, I just spent a half an hour on this super new AI to do something that a Google search would have taken me 30 seconds to do. So sometimes you don't need to have that fancy product if you can get it done in a less invasive way, right? But diligence the vendor, diligence the technology, right? Make sure that it is fit for purpose. We talked about like emotional analysis or whatever, like those things. There's case law on this, and there was a famous case in Hungary about emotional recognition of in the context of a bank, like bank tellers, right? That like they didn't even get to the right risk assessment. They started at the first piece of the risk assessment, which is you are using AI for emotion technology. Have you seen like proof or documentation that says that this actually does what it says it does, right? So look at it, see if it does. Definitely vet, fitness for purpose, reliability of the technology, bias. Anytime that you could theoretically have bias, you've got to look at bias. The FTC talked about it in Rite Aid. Colorado AI Act is focused specifically on the potential of discrimination. So if that could be in play, definitely make sure that it is. You need to understand what the data it is that it's trained on, and the data that is going in, and the data that is going out. And then you need to decide, right? If this is, in some situations, right, it also depends on the use case. You basically need to do a risk assessment and figure out which level of risk this is, right? The more consequential or impactful the decisions that you are utilizing this bot to make, obviously, the more vigilant you need to do. And in your agreement, you get representations from the vendor. You may need to get undertakings from the vendor to update you every time something significant is happening. I mean, those of you that are active in the information security world, right? There, you are required to be told that there is a vulnerability. You are required to be provided with patches. There is a process for if the vendor does something. I mean, we all remember, right, the thing that made all the airlines like stop for a day, right? If there is something that happens, you've got to, the vendors have an obligation to inform you and to be fix this in the information security context. Like, why not here? If the vendor is making a change that could impact your results and process, why would they not need to tell you about it? Why would you not ask them to tell you about it? Why would you not look? And there's like, so that type of conversation and vigilance should be happening. And there will be more clarity about this as the laws get solidified and as now the government is starting to get involved. There is a new set of guidelines on government procurement of AI. And once the government starts flowing down requirements on its vendors, who are usually, right, the big ones, who are also your vendors, there will start to be, and there are more obligations on the vendors for transparency, for documentation, for how this works. That will start flowing down, and all of us will get the benefit of it. But right now, as I said, what you should do is do what you can, right? And we've had situations where we've asked vendors, and the vendors were like, gave us something that we couldn't do anything with and wasn't super helpful, right? But so in that situation, if it's really bad, you're like, well, maybe I use a different vendor. Or if there is no other choice, then maybe you're vigilant and you look for other choices, or you mitigate, or you try to, kind of reduce your risk as much as you can with the tools that you have available.
It's interesting that you say that, Odia, because, I think about so many of the cool, innovative, new players in this space don't have really incumbent players, or are, maybe, legacy, if you want to call them, or incumbent, entrenched sort of brand name players. It's all kind of newer, right? Vendors in this space that may not have that reputation to stake on. So, and it may be the only choice, when you said, how many others did you look at? Sometimes that's the only one doing it. So I think it's really interesting as the technology is so innovative, how you can sort of cover yourself, make sure that, as you said, you're checking in. And to Tim, to your point, that the AI, as it's learning and evolving, is not like out of control of even the vendor that is selling it. Right.
Yeah.
So, I mean, there's just so many things, I think, due diligence and keeping on top of it, and having, I guess, maybe some cadence of documentation of doing your thoughtful review ongoing through the life cycle of that relationship maybe is important.
Odia, in light of all the risks that you have outlined, what are you seeing as the norm in terms of compensating controls that retailers, restaurants are using to kind of accommodate or account for all these risks that they're facing by using these tools? They need to use these tools because it's becoming a meaningful part of their business. How are they compensating for all the risks that they're incurring with these with what you've outlined?
So I think it's all over the place right now. I think everybody wants to do, it's like, I don't know, everybody wants to do it because it's like the cool thing, and also because everybody else is doing it. What, you don't have Copilot? What, you don't have this for your business, right? So I think everybody feels this pressure to do it. And I think that the way, what I've been seeing is companies that have been thoughtful about it, are looking at it, first of all, they're incorporating AI, onboarding AI procurement into their governance process, right? Assuming they have a governance process, it's part of governance, right? So we don't have to like I just said, like you don't have to reinvent the wheel here. You already have a vendor management program for like information security, right? Everybody, all the information security guys are like, yeah, I told you this, right? So you have an information security questionnaire. You should have, you know, a similar process for the AI, number one. So put it as part of the governance. And then the other is I've seen companies look at it and also the laws, right? The government procurement guidelines, the European AI Act, they are taking a risk-based approach to it. So not all AI uses are created equal. If you have a bot that queries your, you know, database that has no personal information in it, no sensitive information, doesn't go anywhere, doesn't go outside the company, queries it and gives you like a link to go, you know, check it, right? You should have a risk-based approach, right? There are the like define risk levels and define what needs to happen in each risk level. And then one thing that I neglected to say, which is important, the more I said pay attention to, the more significant, but like the human involvement component is important, right? Anytime you're utilizing AI to shortcut or to replace or to supplement or whatever, something that is significant, insert an actual human being in there that will make sure, like my situation, there have been, if you, in our field, right, there have been a number of cases of lawyers that are getting disciplined for submitting court documents with completely made up cases that nobody ever checked, right? That is, again, right, I said like everything old is new again, and if you can't do it yourself, don't use AI. Lawyers are not supposed to submit court papers without having vetted the citations, right? Just not a thing that you're supposed to do. That's either when you drafted or when you used a law review article, or you had a first-year associate draft your brief, right? You got to check this stuff. You are allowed, your responsibility. So it's the same thing. If you're the one, you should insert the person to make the decision and vet the product and check it, right? And the more risky, the more important that is. The less risky, maybe you do it and you say, hey, you know, this can make mistake, you know, please check, and kind of, you know, alert people to it. But I think the main point here is that you want to take a risk-based approach and have a policy on, you know, how this is supposed to be used, what are the rules, when do you need to kick this up to legal? And that, I think, is those are the first steps.
Thank you. Thank you for this. This is incredible.
Thank you, Tim. Thanks for the insightful questions. And Odia, thank you so much for your time. I have put in the chat that I just want to reiterate that Odia is available, and you know, her expertise. If you have questions that you want to do a deeper dive, or you want to look at your own individual situations and ask the expert here, feel free to reach out to her. And she's very prolific on LinkedIn, and I love her posts. So I recommend everybody on this call go follow her immediately after this call. But Odia, any last words before we let you go?
No, I think that I think we covered it, but I'll look forward to hearing from everybody, and I'll recap the thoughts. I realize this is I'll kind of try to recap the gist of it, and I'll post it so you can have something, some sort of reference guide.
Thank you. And I'll do a little recap too of just a couple of things that I noticed. And you know, we didn't even touch on biometrics and voice. I know that a lot of people on here are thinking, I think voice bot in the drive-through. So you know, we might need a round two with you at a later.
Those as one statement, those would fall under the sensitive information thing, right? If you are collecting biometrics, that is a sensitive use. That requires a whole level of things that need to be done. And so that is in the category of, you know, get a lawyer before you deploy it, because that's a higher risk implementation for sure.
Yeah, I know that I read something about Presto, and like they said something about 70% of their voice bots have a human in the loop in the Philippines. So what's so interesting is that opening you up to a whole nother set of legal, I thought about the liability that we're discussing on this call when I read that article. So, so thank you again, Odia. This is has been an amazing hour. I think hopefully very useful to all the folks that hung with us. And we appreciate your time. Thanks everybody for joining us. We'll see you next
Thank
time.
you.